How to win in the California small claims court, coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you as always. This is Jordan Farkas, and I am a retired attorney. I've also written several books on small claims court procedure, and I've noticed that we've had some new subscribers join the channel since I recorded my last video. Thank you so much for subscribing. If you have not already subscribed, don't forget to hit that subscribe button and the notification bell. It takes a second. Like the video, share it with anybody whom you think can benefit from it. If you wanted to learn more about me, if this is maybe your first time coming to this channel, there's a bio video on the homepage of this YouTube channel. So without further ado, in today's video, I'm going to continue in the series of small claims courts across the United States that I'm profiling with a video on how to win in the California small claims court. Okay, and as usual, for those who have seen my previous videos, I have my trusty old school whiteboard, which got a bit rubbed out before I started this video, and I don't want to get up and redo this whole whiteboard, but I am going to have to kind of improve my video technology skills so that I can maybe do this in a more illustrative way that's more pleasing to the eyes. But in any case, I do feel like this is a bit of a visual aid so that you're not just looking at my face the whole time. That is, if you are looking at the video, maybe you're listening to this as background while you're working on something or doing the dishes or any other household chores. And if you are, I'm grateful for that as well. And you definitely can learn a lot just by listening. But for those watching, please excuse the whiteboard visual. So let's talk about the small claims court in California. What I've done before is that I've kind of put the tips in red here on the left side of the board, and the various forms involved I've put on the right side in blue. I know it's very hard to read my handwriting, and the print is very small, so I am going to speak it out, not to worry if you are trying to make out what it reads over here. And I will try and put whatever I can in the description below. This is all taken, by the way, from the California Small Claims Court website. I believe it is the website of the Small Claims Court of California. I put it into Google, and that's the first website that came up, and it's an absolutely fantastic website. So I will link to that in the description below, and I do recommend that if you are watching this from California, that you go to that website and learn all there is to learn about small claims court. Then you may ask them, what do you need this video for? Well, again, some people may find it overwhelming to go through all the various pages on the website. And what I'm doing here is trying to kind of streamline that for you. Okay, so I do recommend going through that entire website, but I'm kind of just highlighting important pieces of information that I found. Obviously, I can't go through every single form that there is in California Small Claims Court. I'm kind of picking and cherry picking, if you will, the more important ones. And obviously, I can't go through every single bit of information that the website has to offer. But again, I'm kind of cherry picking what I think is important. And I also try and sprinkle in some strategy that goes with the various procedural stuff that I'm going to talk about so that you are getting that added value. Okay, so first of all, what is the limit of the California Small Claims Court? Well, actually, it's interesting. It's broken down depending on whether or not you're an individual or a business. If you are an individual, the limit, when I say limit, by the way, I mean how much can you sue for? What is the maximum amount you can sue for in small claims court? The maximum, small claims court in California, I should say, the maximum is $12,500 for an individual. And if you're a business, it's actually less. It's $6,250, which is interesting that they do this. I'm not aware of other small claims courts that break this out. Of course, I haven't gone through every single small claims court yet. It is on my list to do that. But at this time anyways, I'm not aware of small claims court kind of breaking that down, but they do that in this instance. Now, what's interesting about the California Small Claims Court is that no lawyers are allowed. I have seen that in other small claims courts as well. But there is this concept of a small claims court advisor in the California Small Claims Court. And on the website, there is a link to how to get in touch with a small claims court advisor. So I would recommend that if you have any questions that you don't feel are getting answered, you contact the local small claims court advisor in the jurisdiction of where you will be suing in small claims court. And there's a whole locator and a map of how to find the right person. I also do recommend generally, depending on the amount of the claim, to get a consultation with a lawyer before you file your small claims court lawsuit. Again, it depends on how much is involved. If you're owed $100, and a lawyer's charging, $750 for a consultation, then that's not going to make much sense. But if you are owed a significant, $100 is also significant, but really, several $1,000 lawsuit, and you really feel like you need that added help, then definitely I always do recommend consulting with a local lawyer in your jurisdiction. That's totally acceptable. Even though lawyers are not allowed in small claims court, that you're certainly allowed to consult with a lawyer either before or after your small claims court proceeding. Okay. Now, the next thing to realize is that appeal. So what happens if you lose your small claims court case? Well, actually, if you are the plaintiff, if you are the one who has filed the lawsuit, you cannot appeal the judge's decision. It is final, which is very interesting to me, again, to see that. That's not something I've seen in many other small claims courts, if not any. But I should say, if you are a defendant, that means you were sued. You're not the one who sued. Then you can appeal. Okay, you've got 30 days from the date of the judgment to appeal. By the way, that also means, let's say you're a plaintiff and you sued a defendant, and then the defendant sued you back in a counterclaim, then you are considered the defendant to that counterclaim, defendant's claim in California small claims court, and in such case, you can file an appeal as well. So essentially, if you are a defendant in the main action, the main lawsuit, or you are a defendant to the defendant's claim, to the counterclaim, only those two parties are allowed to file an appeal. Otherwise, plaintiffs, whether to a counterclaim or to the main lawsuit in the main claim, are not allowed to file appeals. Okay, which is another reason, by the way, you should consider before you sue if you want to try and settle the matter out of court, because you're really in an all-stakes game of all or nothing when you take something to a small claims court hearing, and judges don't always see things the way you do. Okay, especially if you don't have strong evidence. You may think you have strong evidence, but oftentimes a judge will look at your case very differently. So you should always consider settling. This applies across the board, no matter which court you find yourself in, but you should always consider settling before you go to a small claims court hearing or trial, because anything can happen in court. I can't stress that enough. As much as this channel is about helping you win in small claims court, nobody could ever guarantee that you will win. And if anybody ever does, if any lawyer tells you that you're guaranteed to win, then don't believe that person, because there is no such thing as a guarantee. Okay, so certainly you should always consider settling before you get to a hearing, especially in California where there is no appeal if you are the plaintiff. Okay, now there are different rules that apply to different types of cases, so you definitely should be aware. So I gave some examples over here that if, let's say, you want to sue your attorney, let's say you're not happy with your attorney's work and you feel your attorney ripped you off, whatever the case is, there's different rules that apply to suing attorneys, all sorts of timelines and things you must do, such as arbitration. I'm not going to go down that whole rabbit hole. There are links on this website that I'm going to link you to, but just bear in mind there's different rules. Same thing goes for suing governments or healthcare providers. There's different rules that apply, and the website points out that if you don't follow these rules of procedure when it comes to suing these different types of entities, you may be barred from bringing that lawsuit against them. So make sure you follow the rules and you check these rules before you file your lawsuit. The same idea with injunctive relief. What do I mean by injunction? Let's say you have a neighbor who put up a fence that you feel is encroaching on your property. You cannot go to small claims court asking the judge to order that neighbor to remove the fence. To do that, you'd have to go to higher court. However, what you can do is you can sue for damages instead. Let's say it costs you $10,000 to fix that issue, however that may happen, then you can sue for damages arising out of that neighbor's failure to put down that fence. But to ask for specific, what's known as injunction, asking the neighbor to do something or to refrain from doing something, to not do something, that is not something you can ask a small claims court judge to do. You can only pretty much sue for the monetary damages in that regard. Now, the statute of limitations is also something that's very important when it comes to suing in any court, but particularly small claims court, which is the focus of this video. So if you are suing over a written contract, a written agreement with another party, then you've got, my arms are hurting me a little bit holding up this board, then you've got 4 years to sue from the date of the breach of the contract. Now, when the breach occurred could be subject to interpretation. So you got to be careful if you're coming up to that 4-year period. You don't want to wait to the last minute. Of course, sometimes it's beyond your control. Let's say somebody got sick and they're just getting out of an illness and you're getting to that 4-year period. Then, just be careful, because it is open to interpretation what is considered a breach of contract or when the breach occurred. And that will be up to the judge to decide. Now, with respect to verbal agreements, it's a 2-year limitation from when the breach occurred. Verbal is even harder than written because there's nothing in writing, obviously. So it's harder to prove when the breach occurred. There are ways to try and show it, such as text messages and photographs, etc. But bear in mind, for verbal, it's even harder to prove the timeline. And for what else did I write here? For personal injury lawsuits, so let's say you were in a car and you went over a speed bump that the city did not repair, and you suffered injuries as a result. You have 2 years from the date of the injury. Again, bearing in mind that when it comes to suing governments, like I mentioned before, there's all sorts of other rules. But all things being equal, with respect to the limitation period, it's 2 years from when the injury occurred. And with respect to property damage, it's 3 years from when the damage to the property occurred. Now, in terms of jurisdiction, it's something that I noticed that's interesting from the small claims court. I'm just going to put this whiteboard down a bit again because my arm's getting tired. It's also because I've got something in the way here that's just out of the camera view. But in any case, with respect to jurisdiction, there's all sorts of different rules depending on what the type of claim is of where you're going to file. But just know that you have to file in the right county of the California Small Claims Court. And if you don't, you're at risk of having the case thrown out. And if you missed a limitation period in between the time when you filed in the wrong jurisdiction and then had to go and file in the right one, then you may be out of time to sue as well. So you have to be very careful about suing in the right jurisdiction. I would recommend contacting the small claims court to get more information. They can't give you legal advice, but they can certainly point you in the right direction. Again, this website also can do that. And remember, you have the use of a small claims advisor, and you also have the use of consulting with an attorney. Okay, so I'm not going to go into all the different rules. It is on the website, but it talks about if you're suing over property or personal injury, is it going to be where the defendant resides? Is it where your property is located? All sorts of different rules. The website also, I should mention, has different tips on how to find where if you have to locate the defendant, because you do have to locate the defendant to provide them with the lawsuit, then there are all sorts of tips that the website provides of how to locate a defendant, such as checking county records, et cetera, which I'm not going to get into in this video, but just know that those tips are there on the website. And now, in terms of enforcement, okay, I'll go back to the forms afterwards, but I'm just going through all the different things that you should know about the small claims court. In terms of enforcement, so what do I mean by enforcement? Let's say you've sued and you've won. As always with small claims court, as far as I know, when I say as always, of all the small claims courts that I've researched to date, the small claims court will not collect the money for you. You are expected to take means to enforce, to collect on your judgment. And what are the different ways of enforcing? Well, obviously, you can reach out to the defendant and hope that the defendant pays you. The defendant does have 30 days from the date of the decision. And one of the reasons the defendant has 30 days is because that's the time period that the defendant has to file their appeal. If the defendant does not file their appeal, then there are forms which I'll get into in a moment. But in terms of strictly talking about how to collect, one way is that the defendant can actually make a request for a payment plan. And obviously, you have the right, I shouldn't say obvious, I say obvious because I practiced small claims court for so long, but not obviously, but you have a right to maybe dispute the payment plan that the defendant is suggesting, or you can accept the payment plan. Again, remembering a bird in the hand is worth two in the bush. And so that's one option. Another option is a garnishment. I've talked about in other videos, the idea of garnishing wages, meaning if the defendant works at a certain company and has money coming to them, then you can ask the sheriff through what's known as a writ of execution, in this case, with respect to garnishment, to enforce this garnishment of the wages, to take money that would otherwise be coming from the employer to the defendant to go straight to you. That's called a garnishment. It's done through a writ of execution, which is interesting because in other small claims court enforcement mechanisms, the writ of execution has to do with property collection, but here it has to do with personal property, with money. The property collection enforcement measure is actually called a lien, L-I-E-N. That's called a lien, where you can put a lien on a person's property. Then again, as I've talked about in earlier videos, if this person ever wants to sell the property, buyers aren't going to want to buy it with a lien on the property. They're going to want the defendant to pay out that lien so that the buyer knows that they're receiving the property free and clear. So a lien could be a very effective way of enforcing on your judgment. And finally, there is also the idea of a bank garnishment. It's called a bank levy in the California Small Claims Court, where money that's held by a bank for the defendant, you can garnish that. Again, in other courts, it would be called a garnishment. Here, it's called a bank levy, where you can tell the bank, hey, the money that's supposed to be going to your client that banks with you should go to me under this judgment. And you have to serve the proper notices and forms, etc., which I won't get into. But again, the website that I'll link you to in the description does have information on this. And again, you have the small claims advisor that you can check with. Now, in terms of what forms do you need to start the lawsuit and what forms are involved in the California Small Claims Court? Well, the form that starts it is called the Plaintiff's Claim in order to go to Small Claims Court. I believe that's what it's called. Forgive me if I got the terminology a bit wrong because it got rubbed out here as I'm recording this video and my memory is escaping me now, but I believe that's what it's called. Definitely the plaintiff's claim, but I believe the last part of that is order to go to Small Claims Court. Again, I know I'm repeating myself. On this website, it has a link to this form so you can see what it's called. And it's a pretty lengthy form that sets out all the details of how much money you're owed, where the defendant resides. And also, very interestingly, when you file this form, you actually get the hearing date that you are going to have your trial, if you will. It's called a hearing in the California Small Claims Court, and that's put right at the top of the form. So you get that date right away, which is very different than a lot of other courts where you have to wait for a date to be scheduled later. But whatever the case is, this form has that all listed, and it's got all sorts of information for the defendant as well for what they have to do. Okay. And also, as I mentioned before, the defendant can file a claim back, which is known as a defendant's claim. That's the counterclaim where the defendant can sue you back. That is something to bear in mind as well. If you're a plaintiff, you should always be aware that there is a possibility that the defendant will say that not only do they not owe you money, but you owe them money. So be prepared for that if you're willing to deal with the potential stress of knowing that not only will you maybe not win your case, you may not collect on your case, and you may even find yourself with a judgment against you if the defendant succeeds. I'm not saying you should be scared. I'm not saying you shouldn't sue, but it is something to be aware that the defendant has that ability to sue you back. Now, you may make various requests to the court. The defendant, for example, could say that this has no right to be in small claims court to begin with. It's not the right jurisdiction, etc. So the defendant can simply write a letter to the court, or there's a form called the SC-150. The defendant can also ask for a postponement of the trial date. It's called a continuance in other courts, or an adjournment. Obviously, you as a plaintiff can do the same thing. So let's say the trial date that you received at the time of filing your form was good for you, but then later on something came up and you really cannot make it. You can make that request to the court in that form. And then what happens is, after you do have the hearing date, then when the judge makes their decision, it is recorded in what's known as a notice of entry of judgment. And as I said, if you're a plaintiff, that decision is final, no appeals. So bear that in mind. Even if you don't like it, there are no appeals. Then when you get to enforcement, so let's say you've won your case and now it's up to you to go and collect on that judgment. Remember, the defendant has 30 days to file an appeal. If the defendant does not appeal, then the defendant has to file and serve on you and file judgment-debtor statement of assets, setting out where all the defendant's assets are. Now, I would assume that in many cases, the defendants don't do that. They're not so quick to declare that. So there's various steps you can take to try and enforce on that. I'm not going to go through all that now in this video, but know that you can drag a defendant into court, or at least into the court procedure, if the defendant is not complying with those statements of assets. Now, what is the help of getting such a statement of assets? Well, again, if you get such a statement, then you know where to maybe garnish or bank levy the defendant's bank account, or where to garnish through a writ of execution the defendant's wages from their work. Okay. Remember, the defendant is called a judgment debtor once you have a judgment against them. Just like you now are not known as the plaintiff, you're known as a judgment creditor. I say remember because I have talked about that in earlier videos when I talk about collection and enforcement in general terms. And then there is something called the memo to court after judgment. Now, I specifically recorded this one because a very alert subscriber to the channel asked a question in one of the videos about how do you add your interest and costs that you incurred as a result of trying to collect on your judgment. So this answers I had answered the question there that usually the courts will provide for this in their forms. And sure enough, in California Small Claims Court, there's a specific form where you can file that memo to add to the judgment amount how much money you've incurred to try and collect on your judgment. You have to evidence this in your memo. You have to show receipts, how this money was incurred. Calculating interest can be somewhat complicated, but the court website does show you how to calculate this amount of money. So just know that you can ask for reimbursement of these expenses. Again, it's up to you to actually collect on these expenses that you've incurred, but don't forget that you can add them, and it can add up if the judgment continues to go unpaid after a certain amount of time. Now, I forgot to mention when I was going through these forms, very important to know is that you do have to, of course, serve the defendant. Serve means provide a copy of the plaintiff's claim form on the defendant within a certain amount of time. Okay, there's certain 15-day deadlines that has to be filed with the court with proof of service before the hearing. I believe it's stated there 5 days before the hearing. Again, all these procedural things are on the website, but just know that you don't just go to small claims court and file your claim. You have to actually go provide a copy to the defendant and then show the court that you serve the defendant by filing proof of service. Proof of service means that you provided it by hand delivery or by certified mail, whatever the rules allow for in the California jurisdiction, which again is on their website. Okay, but just don't go to court and file your claim and then never provide a copy to the defendant, because you can get to your hearing and the first question the judge asks is, well, did you actually provide this to the defendant? And you're like, what? I didn't know I had to do that. And you can have your case either postponed or thrown out in a terrible worst case scenario. So you don't want to get to that worst case scenario. Okay, but that pretty much sums up. What I did again was I went through different parts of the small claims court process, and then I went back and talked about the various forms that are involved. All these forms are linked on the website of the California Small Claims Court, and all sorts of different tips and guidance is available on that website as well. So if you have a specific question, you can check that website. You can certainly ask me in the description below, just like another subscriber did. I do apologize to that subscriber for taking a little bit of time to respond. I'm trying to get better at actually getting notified when these comments are put up. I'm not sure why I haven't been getting these notifications, so forgive me if I don't respond right away, but I am doing my utmost to respond. Obviously, as the channel is in its infancy, there's a greater chance that I will respond to each and every comment and or feedback. As the channel continues to grow, that may be a little bit more challenging, but always feel free to leave a question or comment and your feedback below, which definitely helps improve the experience for everybody, as well as helps me improve on delivering these videos to you. So I do hope you found this video helpful. Don't forget to like the video and to subscribe if you haven't subscribed yet. Don't forget to hit the notification bell. This takes a second and will help you not miss a future video. It also helps me to continue to produce videos just like this. If there's a specific topic you'd like me to do a video on and I feel like there's enough demand and I have the value to add, feel free to leave that in the comment section below and I'll do my best to do that. As always, I'm very grateful that you came to the channel, and until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.